that Professor Broyd has brought one of 2 volumes to Israel. You probably won't have to pay extra for the luggage.
First of all, it's an excellent, there's 2 volumes to this book. I only brought one because the second volume is exceedingly thick. The second volume, the one that I didn't bring, is the written, I'm going to use the term piskei din from this court. And it itself is very fascinating. And then, of course, there's Jay's fascinating analysis, which is this thinner volume. I've read this volume cover to cover. The psakim themselves, sort of, you can't read them through because they're outside your area of expertise. I meandered through the ones that I felt comfortable with. I want to make a few observations.
שלום, וברוכים הבאים לשירותי הבדיקה של סקייפ.
I wanted to make a few observations about it, and maybe use it as an opportunity to talk about a few observations about halacha itself. First and foremost, it's important to understand that most batei din don't record their decisions in this kind of way, and case law rules thus are rarely present, other than the piskei din rabbaniyim in Israel, which is a relatively modern literature. Even batei din that regularly issue piskei din, in the sense that they hand the litigant not just a psak, but reasoning behind their psak, they do not collect them, they do not publish them, and even more importantly, they do not perceive themselves bound in the next case by the decision they issued in the previous case. There is no, what we call in American law, case law, rule of precedent. The one thing you should know about in America is that when the Supreme Court rules, the courts of appeals fall in line. And if they don't fall in line, they get hammered. Of course, you can point to occasional exceptions, but nonetheless, it's a very good rule. Not so in the batei din, which is both in Israel and in America. Case law precedent is weak. Part of the process of establishing case law precedent is having batei din issue written psakim. Here, this sort of is only happening centuries later. But it's worth meandering through them because what I saw was no law of case. Even when they recorded a decision, they don't say, as we ruled in the previous case, we apply that rule here. Not at all. Every case is decided as if there were no previous cases. The second thing that you get from both of these books is the importance of second-tier halachic authorities. And how they rule in a court. You see here, there's an Av Bezdin who I had never heard of. And, I don't know everything, but I've been around the halachic universe for a while. In many different centuries I've dabbled, and you see here a rabbinical court run by an Av Bezdin that firmly rules for a multi-year period, has profound influence on a fairly large community, and fades into obscurity afterwards. This is true in my own involvement in the Beit Din system. The Av Beit Din serves a very important role, and when he serves for an extended period of time, leaves an indelible mark in large segments of the community, and is not a historical figure at all, and frequently doesn't leave recorded piskei din in any way, shape, or form, even though he might have written dozens and dozens of them. They don't get published. They don't get recorded. They don't enter into the classical halachic literature that we all study, unless somebody takes these piskei din and publishes them approximately contemporaneously. The third thing, of course, is to recognize that dina de malchuta dina in the real world plays a very profound role day in and day out. I spent 15 years being Yoshev Bedin. And the Dina de Malchuta Dina theory and the Dina de Malchuta Dina reality do not correspond. The truth is that the litigants conduct themselves in accordance with secular norms that are out there, particularly in an integrated economic society, as you are studying, as at least in America, we are living. Everybody conducts themselves according to secular law, whether they call it Dina de Malchuta Dina or they just call it Minhag HaSofrim. The influence of the wiggles of secular law become profoundly important, and people will not go to Beit Din when they can go to secular court and win. And the Batei Din in this case are astonishingly aware of it, and the Batei Din in America are astonishingly aware of it as well. Only in certain obscure family law areas where the secular courts are frequently powerless do the Batei Din genuinely do as they wish. But when it comes to commercial law, our code not only provides an alternative forum, it provides an alternative choice of law. And don't miss the fact that if you don't line up your law with their law, you get hammered, because litigants say, I need to pick the forum where I will win. That's the kind. Most people do not say, I think I'll pick a forum where I will lose. Okay, nobody says to their attorney, I'm looking to lose this case. What forum should I choose that increases the likelihood that I am going to lose? Can you please give me advice as to which forum I will lose in? So, at least not in my experience. And so it's important as you read a work like this from centuries ago, you see how things don't really change. On family law matters, the secular courts are much less powerful than the rabbinical courts, at least in the committed Jewish community. But in commercial law, the Jewish law courts line themselves up tightly behind enforcing the secular law. They use secular terms. They are deeply interested in what's going on in the secular legal norms. The Av Beit Din plays a very crucial role in actually structuring what's going on, and the rabbinical courts don't have a case law precedent. I actually have a theory which I'll throw out that I hope you'll comment on. The rabbinical courts do not have case law precedent because they know fully well that a huge amount of what they're doing is secular law, which ever changes and which they don't understand. And when I'm just mimicking the secular courts, and I know I have to step wherever French law takes me, wherever American law takes me, wherever Israeli law takes me, I can't do law of the case, because law of the case implies a deep understanding with both what's going on now and where I think the future will be. And if all that I'm really doing is just mimicking secular law around me, I'll do that. But don't ask me to talk about precedent, because I don't actually well understand what I'm doing. So I'll share that with you not as a presentation, but as somebody else's presentation. And then I'll sit down and let somebody else say more. Please.
Let's let the author respond.
Please, yes.